Okay, Mr. Bodoff, go ahead.
Good morning. May it please the Court, my name is Joseph Bodoff. I represent the appellant AVX. Cabot has a monopoly on a certain type of tantalum called flake powder, which is essential to some of the products that AVX sells. Although AVX had a binding agreement with Cabot for Cabot to sell it tantalum during 2000 and 2001, Cabot threatened not to sell to AVX unless AVX entered into a new long-term agreement at double the prices that it was currently paying.
Had AVX ever treated those contracts, I guess they're entitled letters of intent, as binding in the past?
Yes, I believe so, Your Honor. There's two aspects to the letters of intent as they are called that.
Mm-hmm.
One aspect of the letter of intent, which everyone seems to be, or everyone meaning Cabot and the lower court seem to be ignoring, is the take-or-pay provision in the contract. The take-or-pay provision, which there's two letters of intent there involved, but they're on pages 311 and 313 of the appendix, at least the language that I'm quoting. Each one covers 2 pages. It says AVX agrees to take or pay for a minimum of, on one of them, 26,494 kilograms of C606 no later than 18 months after the commencement of year 1.
So C606 is one of the products.
That's right.
Many products covered
right.
by this letter of intent.
That's right. So there's two aspects of it. There's the flexible aspect of it, which we refer to as the requirements part of it. But then there's the take-or-pay provision.
But the take-or-pay only applies to, as I say, one of the many products that are listed on the front page.
Absolutely. But
so you don't have to take or pay. So it's not binding. So under your analysis, it wouldn't be binding with respect to anything else?
There wouldn't be a requirement for AVX to purchase specific amounts of the other types of tantalum. But because there's a take-or-pay provision, provides consideration for the contract under basic contract law. The fact of the matter is that the parties, and getting to that point, let me talk about some of the provisions that we believe make it a binding contract, and the fact that the parties treat it as a contract.
I thought in the past, at least as I read some of the correspondence here, and I may be incorrect, that when the price went down, when supply was of the powders and the various other forms of the product were up, AVX basically demanded lower prices, and if they didn't get lower prices, then they just didn't buy. Isn't that fair?
I think there are some allegations to that effect, Your Honor. But the fact of the matter is that there is an agreement in place.
Something in place. Letter of intent, whatever that is.
It's obviously it's called a letter of intent, and the record shows, and for summary judgment, I think it needs to be taken as true.
Well, why is that? I mean, if this is you say this is a contract. What it means is a matter of law, isn't it?
What I was going to say, you're correct, Your Honor, but except for the fact that the label letter of intent, the record shows that was simply a label that was chosen by AVX. I don't think the term letter of intent has an independent significance here. I think that's the point that I was getting to. So if you get past what the language of it says, and you take a look at, in particular, this letter of intent, you will see that in this letter of intent, we not only have the take-or-pay provision, but we also have a number of corrections made to the document that are initialed by the parties. Not the kind of situation that you would expect to find where the parties didn't expect that the document was to be binding.
Well, the problem with the letters of intent that I see, and for your case, is that I think in 2001 there was a new contract signed, which expressly said all prior letters of intent, agreements, so on and so forth, were out the window. And AVX had competent counsel when that was signed. It seems complete and clear on its face. So what do you do about that?
Well, we have asserted that that new contract was entered into by coercion. And as a
But
result,
why was it any more than the normal market forces? Just like when the prices went down, you wanted to get the benefit of the downswing.
I think once you have a contract in place, the other side cannot threaten to breach the contract and use that as a basis to go and take advantage of the price that it didn't negotiate in the first instance. The fact is...
What case says that?
Well, I think first of all, coercion is a question of fact. I think it's a question of fact. I think the fact that when you have a contract, I think one thing you want to look at is the wrongful conduct. It certainly is wrongful for a party to intentionally breach a contract. With AVX having a contract in place that called for tantalum at certain prices, that for Cabot to turn around and say, we don't want to sell it to you at those prices anymore, and we have a monopoly on some tantalum that you require for your production, and you want to know something? If you don't sign this contract, we not only are going to ignore the existing contract that you have, but you're just not going to get any tantalum.
Didn't the trial judge conclude that there were two very sophisticated parties represented by very competent counsel, that if you didn't want to agree to that idea, you didn't have to sign the contract?
I see that the judge said that, and I understand that he came to that conclusion, but that doesn't mean that there wasn't any coercion. No different than, might I say, the coercion that was found in the General Motors versus Fire Pond case, which we cite. It's a Superior Court decision in 2003, where the court denied a motion for summary judgment filed by Fire Pond on the grounds finding that GM had made out a case. General Motors, huge General Motors, of course represented by sophisticated counsel, had made out a case of coercion. So I don't think the fact that we had big companies with sophisticated counsel makes the issue any different.
I am confused about one fact. What year's contract are you calling the contract that you had that Cabot breached?
It's the letter of intent, which covers years 2000 and 2001.
But that's it. The letters of intent seem to me the terms were always being varied, that when you didn't like the terms of the letter of intent because the prices went down, you asked them to modify the price. Isn't that true in the past?
The answer, whether we did or didn't...
No. Why don't you answer my question?
Well, I think there's some evidence to that effect, but whether we did or didn't really isn't important, because the fact is parties can enter into a contract that as long as it is supported by consideration, will set the terms. So this is an agreement whereby Cabot has agreed to sell to AVX under certain terms. Whether or not AVX committed to buying under those terms is irrelevant if the contract is otherwise supported by consideration.
So why didn't they call the 2001 agreement a letter of intent or a superseding letter of intent? Why did they call it a supply agreement?
Well, according to the record, AVX said that it chose the term letter of intent because it wanted to signify the fact that it wasn't committing to purchase specific amounts of tantalum. What it was doing was setting forth its intention of what it was going to purchase,
so
and Cabot was setting forth the prices.
If you weren't committing to anything, how could there be a contract when you reserve the right not to commit?
But we were committing, and that's the point that I'm making. Paragraph
But
6,
you weren't committing in writing.
Yes. AVX agrees to take or pay for a minimum of 26,494 kilograms of C606. The C606 prices are set forth here at $579 per kilogram for 2000 and $596.37 for 2001. Take or pay means that if you don't buy it, you pay for it anyway. I mean, and there's evidence in the record to that effect, and it's a common term.
Was that the product that Cabot was threatening to withhold?
No. It's the numbers are it's in the 500s, I think, but it's not the C606.
What do we do with the fact that AVX waited 18 months to repudiate this contract?
Well, a good question. The question is, first of all, whether it actually waited. We start with one concept, and the concept is that there is no waiting until the coercion is removed. And here's what happens. Cabot holds a gun to AVX's head and says, if you don't sign this contract, you're not getting any of the tantalum product that you need to be able to operate your business. With the contract being signed, there's no reason to believe that Cabot, who has already breached one agreement, isn't going to breach the next agreement when you turn around and you say, I'm sorry, I'm going to sue you, and then all of a sudden stops delivering tantalum. There is evidence in the record of some discussions and some language from Cabot itself suggesting that even on a breach of contract, its customers will not sue it. From page 782 of the appendix, according to Hugh Tyler of Cabot, quote, our legal exposure here would be small. Why would either customer sue us and risk getting zero powder in the process? And that was in reference to contracts that it had admitted were already in place. So we're talking about a game of hardball that was played here, but hardball ignoring the rights of the parties. It's one thing to negotiate when you don't, in a hardball manner, when you don't have a binding agreement in place. But when you do, and it's clear that it's the...
Well, if you're playing hardball, why would you send an email message saying, Tom, I think we have a fair agreement for both parties?
Well, first of all, in the context, and you're talking about the email message from John Gilbertson, you have to look at it, first of all, in the context of what was going on. And there's two things to keep in mind. First of all, Cabot had already, one, not only threatened to cut off the tantalum supply, but it also lied about the fact that there was or was not tantalum.
But this sounds buddy-buddy, that email message. It sounds like it doesn't sound like somebody who just responded to an act of coercion.
It sounds like someone who is trying to go and save their business and to make sure that they get the product that they need to keep their business. It's survival of the business first. We'll deal with the legal issues later. Now, in specific comment to what you're saying, I agree that a jury might be able to come to the same conclusion that you just argued. But what we're arguing for is that to let the jury decide that issue in the context of the lies from Cabot, the fact that there was an existing agreement in place, and the whole series of communications that went on.
It's interesting. The agreement is effective January 1, 2001. And again, the record is lengthy, and I certainly haven't reviewed all of it. But it appears, consistent with some of the points made in the Cabot brief, that as of February of 2001, AVX was really insisting that Cabot beef up their production to meet the contract. I mean, they were saying, hey, we have a contract now. You know, we want the stuff, and you're not producing it fast enough for us. Isn't that a form of ratification? Isn't that deriving the benefits of the contract?
No, because there's two aspects to the contract. One is you now have something in place. You have something that Cabot's going to be prepared to go into court and sue you over if you don't comply with the contract. You're talking about a totally different environment there. Once you get into the...
So AVX is... Well, okay. But AVX is demanding that Cabot live up to the terms of the contract, is what I'm saying.
I understand that, but they also negotiated certain terms under the contract. Now, we're also talking about a period of time that the letter of intent otherwise would have been in force. And yet you're taking a look at a situation where having negotiated that deal, Cabot was trying to get whatever benefit it could, but even the benefit that it was getting under that agreement within the confines of that agreement was not not what it was otherwise entitled to under the letter of intent. And as we pointed out, the letter of intent called for prices that were half the amount of the
I understand. Well, the whole world market had gone nuts. I mean, the prices, market prices were through the roof. We're not talking about you being singled out for pricing that wasn't in the marketplace.
It would have been okay if we didn't have the agreement that entitled us to
The letter of
get that
intent
lower
from.
price.
Okay. One other question. Talk about the delay that Justice Graney had mentioned, or the period of time before you protested or filed suit or brought some action saying that there had been coercion here. Again, looking at a portion of the record, it looks that by May of 2001, only a few months later, there's correspondence, AVX correspondence, internal correspondence, in essence saying, look, demand is decreasing, we're stockpiling the stuff, come fall, we better renegotiate with Cabot because we're not going to need all of this supply. So it seems to me that really almost early into the contract, all of these pressures that had been building up through 2000 in terms of supply were starting to release already. But still, it was a year plus before.
It may have been, but you'll also notice that within 3 months at the latest, after the contract was signed, and there's plenty of evidence, the record going all the way through April and May of the following year, the parties were renegotiating the contract. As John Gilbertson stated in his affidavit, it was only after those negotiations fell apart that suit was filed.
Thank you.
Thank you.
May it please the Court, I'm Robert Frank. I represent Cabot Corporation. AVX, the allegedly coerced party, is an enormous and an enormously profitable corporation. At the relevant time, it had $2.6 billion in annual sales and annual profits of more than $500 million. It was organized into 7 divisions. Cabot sold product to one of those 7 divisions, and at the relevant time, it supplied only 20% of the purchases of that division.
But didn't it supply 100% of some of these specialty items? Wasn't it the sole source of some of these specialty items?
Cabot it makes something called flake powder. Yeah. AVX claims that it needed flake powder for its Biddeford facility. It is undisputed on the record that the Biddeford facility does not use flake powder. Furthermore, for years, Cabot had tried to get AVX to enter binding long-term agreements, and no market power that Cabot had at that time persuaded AVX to enter anything other than the letters of intent that you see before you.
But I'm just getting back to the point, saying that they provided 20% of this product, which comes in various forms, powder, flake, wire, etc.
Yes.
Doesn't help me very much if, in fact, they're the sole source and only supplier of one key ingredient.
But it is one key ingredient used in a very small number of an enormous number of tantalum capacitors that AVX makes, which are a small part of an enormous number of all capacitors that AVX makes. So the point is simply that it is a minuscule aspect of AVX's extraordinarily profitable business. It doesn't, in fact, and didn't in history, give any leverage to Cabot. What gave leverage to Cabot in this situation was a turn in the market. AVX and its capacitor manufacturer competitors were doing so well because they were selling capacitors into cell phones and personal computers, and there was an enormous boom that the demand for tantalum that goes into the capacitors simply got to be much larger than the supply of tantalum. And when that happened, what had been a buyer's market became a seller's market. And what Cabot did, essentially, was use the fact that it had tantalum supply that AVX needed in that context so that it could make even more money than it was making, and it insisted on or asked for, bargained for, the very long-term contract that they had been asking for years.
But would you agree with me that if there was an existing contract in place, would it be proper for Cabot to say, we're going to breach that contract unless you, and you will suffer because you desperately need these products, unless you sign a far more lucrative contract for us?
If there were an existing contract in place, and if the terms of that contract were reasonably clear, then it probably would have been wrongful behavior to insist upon compliance with the clear terms of a contract. But that is a counterfactual assumption. What was present here was something that is entitled a letter of intent, and the words of which the court can look at as a matter of law, say only that it is AVX's intention to purchase certain amounts of tantalum, certain types of tantalum at certain prices. As Your Honor pointed out to my adversary, the actual practice in the past was that AVX had in fact been free and had in fact reduced its purchases to zero when it didn't like those prices. It admits that it was not bound by those to buy anything under those contracts, and yet it claims that Cabot was bound to sell everything.
Well, what about the take or pay provision?
Thank you.
Paragraph 6, at least in the one.
There is no evidence, none, that Cabot ever said that it would not supply that particular product. There is no evidence, none, that AVX ever said that it wanted that product, and there is no evidence, none, that AVX ever actually purchased C606 under the supply agreement that the parties entered. A complete red herring. And let me just stay with your question, Justice Cordy. I don't think I have to persuade you that Cabot was right, that the letters of intent were letters of intent, that Cabot was right as a matter of law. I think I only have to persuade you that its position was reasonable, and I would call the Court's attention to a decision by the First Circuit decided only a couple of months ago in a case called Happ versus Corning, 466 Federal 3rd at 41. It is a coercion case, and in that case there was a contract and there was a dispute as to the meaning of the contract, and the party that was ultimately disadvantaged by the contract argued that it was coerced into entering that contract. And what the Court said is, the Court said that the alleged coercing party had taken a position that was not unreasonable, although this position might not have prevailed in court. Corning, the alleged coercer, had a plausible, if debatable, position that the undertaking that it sought was within its rights. And then the Court concluded that an act is not wrongful in this sense if there is a good faith belief by the pressuring party that its position represents a plausible one to take under the governing contract.
Is that a decision that can be made on a summary judgment record, or is that
Yes,
a finding of fact? Is it a finding of fact that needs to be made?
No, that case, that's the First Circuit affirming a summary judgment.
If I'm looking at the right contract, and correct me if I'm wrong, but it was a 5-year contract, was
Yes.
it not? The prices were no higher for the product than the current prices, market prices?
Yes, it is correct. The record evidence is that the then current market price was $500 a pound, that AVX had purchased from other suppliers tantalum products in substantial quantities at $500 a pound, and that it had purchased on the spot market at substantially the same time product at up to $2,200 a pound.
AVX got most favored customer protection?
It certainly did.
If Cabot were in the future to agree to sell to one or more of AVX's competitors at a lower price, either the powder or the wire, Cabot would sell the same quantity to AVX at the same price?
Yes, absolutely.
AVX obtained the right to purchase additional products in the event of a plant expansion?
Yes.
And AVX waived all claims relating to the 2,000 letters of intent?
Yes.
I don't see anything unfair in that contract.
One of the elements of one of several elements of a coercion defense is that there was an unequal exchange of values. In a time of rising prices, they capped their prices at then current market. In a time of short supply, they assured themselves of an adequate supply of tantalum, and they protected themselves against a downturn in the price with the most favored nation provision. They have the burden of establishing a dispute of fact with respect to whether that was unfair. And just as you're saying, Justice Graney, this was a fair contract. It was not. They did not have there was not an unequal exchange of values. Let me just, if I could, say that the elements of a coercion claim are, one, that Cabot caused AVX's duress. Two, that Cabot caused AVX's duress by conduct that was wrongful, not hard bargaining, wrongful conduct. Three, that AVX had no effective choice in the matter. And four, that there was an unequal exchange of values. If we prevail, if we persuade you that there was no genuine issue of material fact on any one of those issues, we win. And as Your Honors pointed out, so the arguments Your Honors made, the arguments I would have made on the unequal exchange of values, it is simply not wrongful conduct to bargain hard. It is not wrongful conduct to take advantage of a market situation that Cabot did not create, to bargain for something that Cabot had asked for years. One of the arguments that AVX made that wasn't made this morning, but I'll just comment on, is that Cabot misled AVX by saying that Cabot did not have material to sell to AVX. The argument goes no place. On the left side of their mouth, they say that Cabot was misleading AVX into believing that Cabot did not have product to sell. Out of the right side of their mouth, they say that Cabot forced them to take the particular quantities of tantalum that are in the contract. AVX could not have been misled about the fact that Cabot had the product that Cabot was contracting to sell to it. The final point on duress is simply that there are a legion of decisions which hold that if a party has an alternative, there cannot be duress. And an alternative is the existence of an adequate legal remedy. In Delaney against Chief of Police of Wareham, Your Honor, then sitting on the appeals court, said, and I quote, "Absent compelling circumstances, the availability of a reasonable alternative, such as a legal or administrative remedy, will defeat a claim of duress." There's a First Circuit case called Ismert, where Mr. Justice Breyer says the same thing, and in the recent Happ case, the First Circuit said the same thing. AVX says in response to that, and the judge below said, that's right, you could have come in here and asked for a preliminary injunction if you were afraid. If you thought you were right, you could have come in here, sought a declaration that what's called a letter of intent is not a letter of intent, it's actually a binding contract. And if you could have persuaded me that there was a reasonable probability of success on the merits and irreparable harm, you'd have gotten your relief.
Yeah, but surely, had that such as had been brought, Cabot would have argued that this is all curable by money damages.
If so, Cabot would have argued either that there was not a probability of success in the merits or that there was not irreparable damage. Either way, that kills their duress claim. If there's no irreparable damages.
There's no irreparable damage only in the sense that you can eventually be compensated with money. But, you know, if it's a product you absolutely need, that's as a practical matter, very hard to do. They don't want the money. They want the continuing flow of product.
Let me say two things. One, unlike some of the duress cases, this is not a company that was at death's door. This is a company that had enormous amounts of money. If Cabot was in breach of contract and AVX was actually going to be damaged by that and it was actually right on the merits, it could get every cent back. And it would be none the worse off. As I pointed out in response to Judge Cordy's question, there's a tiny Cabot, the thing that is said to be a monopoly is a minuscule percentage of what they purchase. And with respect to everything else, assuming that we're misleading someone, they could have gone to anybody else in the market. They couldn't go to anybody else in the market because there was a shortage, but that's a different question. The law, Your Honor, the law is that if you can go into court, if there is an available remedy, a preliminary injunction, specifically the subject of the Ismert case, that is a reasonable alternative. But I don't, even if I haven't bulged over with respect to that, let me say that is just one of 4 elements of coercion, and we prevail if we win on any one of them. Let me talk about a ratification for just a moment, if I might. What happened here is the contract was signed in January of 2000, and at the time, supply was very tight.
January 2001?
I misspoke, January 2001. At the time, supply was very tight. Sometime in the spring or summer of 2001, the dot-com boom ended, the demand for capacitors went down, and AVX found itself in a position where it no longer liked this contract. But it waited for a period of 18 months between the signing of the contract and the time that it first asserted in court or out of court the existence of coercion. In fact, during the short supply periods, it is undisputed, AVX demanded that Cabot ship as soon as possible and as much as possible. In addition, AVX sought under the contract, to amend the contract. There's a letter in the record acknowledging the existence of the contract, requesting an agreement to amend the contract. Cabot actually agreed to that amendment. Cabot requested amendments. AVX, without disputing the existence of the contract, agreed to those amendments. And so the parties actually acted under the contract. There was here a prolonged period of participation under the contract. Only when AVX no longer wanted to buy product did it turn and say that this was coercion. And that's exactly what the ratification doctrine is designed to prevent. It is designed to prevent someone from taking the contract when they like it, wait for a change in market circumstances, and then take a different position.
Thank you.
May I have 30 seconds?
No. Thank you.
Thank you.